An appeals hearing was held today in the case of James and Jennifer Crumbley, the parents of the Oxford school shooter. The Crumbleys now facing 4 counts of involuntary manslaughter.
And the hearing today will determine whether they should go to trial for being partially responsible. CBS News Detroit's Ray Strickland reports on the arguments made by the prosecution and defense and how the focus is on what the Crumbleys did or didn't do to prevent the shooting.
The word foreseeability was something heard often inside of the courtroom today, an argument the prosecution is using to make their case, saying the Crumleys should have done more to prevent this shooting. But on the other hand, the defense says they could not have predicted what their son did and should not be responsible for his actions.
4 counts of involuntary manslaughter arise out of the deaths of the 4 students at Oxford High School.
Speaking before 3 appeals court judges, the prosecution and attorneys for Jennifer and James Crumbley gave oral arguments today in a hearing that will determine if they should go to trial in connection to the Oxford school shooting.
There are so many things you could point to that could be foreseeable or not, but at the end of the day, it truly wasn't foreseeable that EC was going to take this gun and shoot people. It was not foreseeable to his parents.
Contrary to defendant's argument, the intentional act was foreseeable. This is a case where months before the shooting, these parents knew he had reported hallucinations. They knew he had asked to go to the doctor, and they did nothing.
The focus of the hearing was if the Crumbleys could have predicted or even prevented the shooting. The prosecution argues they knew about Ethan Crumbley's mental health concerns concerning school assignments and even bought the gun used in the shooting. The judges also questioned whether the Crumbleys could have done more on the day of the tragedy.
You have that math worksheet, which is so troubling, and they both understood that was tremendously troubling. And yet, they came into the school, true, good for them, but then they just left. Didn't hug him, left the school, left him in for the rest of the day.
They also didn't look in the backpack.
Everyone was convinced EC was not a threat to other people's safety.
They could have checked to see if he had the gun they just gifted him days earlier on him. They could have simply taken him home from school. They could have adequately secured that weapon. There are a number of things that these parents could have done to exercise ordinary care in that situation.
The Crumbley son went on to shoot and kill 4 students at Oxford High School while injuring several others. But despite the judges acknowledging the Crumbleys' missteps in the months leading up to the shooting, the prosecution's unprecedented move to charge the shooter's parents is one of concern for Judge Christopher Murray.
I think it is a valid concern about the precedent that this will establish and lead to issues that you mentioned about parental criminal responsibility for the intentional acts of their children.
The father of one of the students killed in the shooting was asked if he believes the Crumbleys should be charged. Here was his answer.
They bought a gun for their kid, right? And he used it. Murdered our kids, man. Yeah, absolutely. I don't care if there's not a law out there or not.
In Detroit, Ray Strickland, CBS News Detroit.